Okay, folks, this is the recording, the video covering Note 7, which gets us into the First Amendment and various First Amendment concepts. I will, at this point, be covering a note. There are four of them called Note 7. I'll be, first of all, talking about the one that is Introduction to the First Amendment Concepts. And then, if we have time, we will lead into the next one, which is other First Amendment freedom of speech issues, and we will do a separate video on the other two Note 7s, which basically cover First Amendment freedom of religion. So we're going to do a little bit of talking about the First Amendment in general, and then we'll get into freedom of speech issues and leave freedom of religion to the next video. All right. The First Amendment. Justice Benjamin Cardozo of the Supreme Court, who was a preeminent scholar and justice in the 1930s, said that the First Amendment is the most important of all amendments. It's the most important of all our rights because it deals with our freedom of expression, our right to express ourselves, to have thoughts that are different from those of the government, beliefs that are different from the government, and to express them, to state them, to make them known to other people, to share them. He basically called freedom of expression the matrix, the indispensable condition of nearly every other form of freedom. So in Cardozo's mind, the First Amendment rights, freedom of speech, were basically the stepping stone to all the other rights, and that without these, you would really have nothing. Very often, you'll hear the First Amendment described as containing the five freedoms. And these are freedom of speech, freedom of the press, freedom of assembly, freedom of association, and freedom to petition the government for redress of grievances. All of these questions arose out of some very severe and difficult times in English history, where the kings and parliament had tried to maintain severe control over the people and tried to severely limit these freedoms. And they were written into the Constitution really in a reaction to what the writers and drafters of the Constitution had gone through in dealing with the British government and what their ancestors had gone to that had forced them to leave England and to come to North America to establish new lives out from under the thumb of the British monarchy and of the British Parliament. First, talking about freedom of speech. The issue of freedom of speech and how the courts deal with it. And first of all, we have to remember now, again, when we're talking about freedom of speech here in the First Amendment, we're talking about freedom from governmental interference. It doesn't really deal with private entities and who can speak when or what within a corporation or an employee to an employer. We're talking about the government trying to control or regulate or stop a citizen from speaking. And as with all other rights, initially, the First Amendment only applied to the federal government, and it was only through the 14th Amendment, the principle of incorporation of the Bill of Rights based on 14th Amendment due process and equal protection guarantees, that the First Amendment came to be applied against the states. And as with most of the other rights that have been incorporated, that did not happen immediately after the Civil War when the 14th Amendment was passed. It was the early 1920s before the court really began to look at the First Amendment in terms of applying it to the state government as well as to the federal government. Now, one of the things that the courts are very concerned about is something called prior restraint. Prior restraint is the idea that somehow we could stop you from speaking, that if we thought you were going to say something, you were going to make a speech, you're going to hand out pamphlets, you're going to put an article on the internet, that we could run in and stop you from doing so. And the courts have long talked about being very hesitant to do that, saying that that creates what they call a chilling effect, that if it becomes known among the public and among the population that the government will try and swoop in and stop you from speaking, that actually has an effect far beyond the actual couple or several cases where they apply that, because many other people begin to become afraid, they begin to become worried, they begin to become concerned, and they would actually self-censor based on their fear of what the government would do to them, what could happen to them. So a lot of times when courts are looking at First Amendment issues, one of the things that happens is a lot of times cases get thrown out because they're brought too early. Somebody's actually trying to stop someone saying, Your Honor, we think they're going to put this in their newspaper, make them not print it. And the courts are very hesitant to do that in many situations where possibly there may not be a violation of the First Amendment by stopping this or by punishing this speech. The case will still get thrown out because we're bringing it too early before the people have actually started speaking. The First Amendment was not applied to the states until 1925 in a case called Gitlow versus New York. And even in terms of bringing First Amendment cases against the federal government, they were very slow in coming. It was a very difficult concept to develop in terms of freedom of speech. In 1798, right after the Constitution was enacted and the Bill of Rights were passed, the Congress passed something called the Alien Sedition Acts, which made writing or publishing any false, scandalous, or malicious words against the United States Congress or the President a crime. That was never overturned by a court. No court ever. It was never highly utilized, so there weren't a lot of people prosecuted under it, but it was never overturned. It sat there for as long as it was on the books, not being deemed unconstitutional. Today, it would absolutely be considered unconstitutional, and Congress would not be allowed to pass and enact a law of such nature. Another concept divide that the court uses is the division between something called pure speech and expressive speech. Pure speech is speaking, writing, publishing, and that publishing could be in a newspaper, a magazine, on the internet. But it's the idea of actually verbalizing, vocalizing, or writing words on paper. As opposed to that, they look at expressive speech as being picketing, marching, protesting, other actions that you take where you are trying to convey a message. They still look at those actions as having a speech component or being part of speech, but they tend to be far stricter in what they won't allow the government to do in terms of pure speech than they are with expressive speech. They tend to allow the government more leeway in controlling activities than they do in controlling mere words. All right. Even spoken words can be controlled to a certain extent, and even the most ardent First Amendment advocates, attorneys who practice in this area, recognize that there are times when speech can be controlled. The classic example of that, which I believe was first stated by Justice Oliver Wendell Holmes at the beginning of the 1900s, was that free speech does not give you the right to yell fire in a crowded theater when there is no fire. So that speech that would provoke fights, disagreements, arguments, physical violence, defamatory speech, speech that could be dangerous because of the way people would react to it, has been at times limited by the court, and the courts have given the governments a right to impose penalties for that type of speech. Right? And again, going back to the idea of pure speech versus expressive speech really comes into a wide area of stuff. All right. So any type of expression, any type of communication can fall within the First Amendment protection. Protests, demonstrations, as we said, performances, advertisements, artistic endeavors, records, films, videos, software, video games, emails, broadcasts, cable TV, internet sites, all of these areas fall within the First Amendment protections. There are government controls to more or less extent in certain areas, such as you cannot open up your own broadcast radio station or TV station without government permission, without a government license, or without government recognition. But once you have that license, the First Amendment comes into play, and what limits the government can place on what you are going to state over that radio wave or over that television network. It is quite limited, actually. Okay, now, again, going back to what we talked about a minute ago, the government really only has two ways to control speech. And one is prior restraint. We attempt to stop and enjoin the party from speaking. We attempt to impose an injunction, which is a court order saying you cannot do this. Or we punish after the fact. We pass laws that make certain types of speech illegal and punishable, and we do not attempt to stop people. But if they engage in those types of speech, then sanctions can apply. The government can punish them and apply civil liabilities or even criminal liabilities. Now, the idea of even normally, courts will not, as I said before, they will not engage in prior restraint. They will wait to see what happens, and when the government goes in to try and prevent certain speech from happening, they will usually dismiss the case. There have been exceptions to that over the years, and those exceptions have to deal with national security. And wartime, the limitations on free speech can be curtailed to protect the wartime activities, all on the idea that this, the country, the republic, the people need this for their protection. And in those situations, the courts have said that for national security reasons during wartime, speech can be limited. However, the last really large case that has come down in that area was in 1971 during the throes of the Vietnam War, when there's tremendous amount of protesting and demonstration going on about the war. Some people managed to smuggle out of the Pentagon a top secret document called The History of the U.S. Decision-Making Process in Vietnam. It came to be called, affectionately in slang, the Pentagon Papers, and it was clearly illegally disseminated. It was classified. It had been held secretly in the Pentagon. It was not for public consumption. So somebody somewhere along the way broke the law and released this information. It got into the hands of the New York Times. Well, the Nixon administration attempted to prevent the Pentagon Papers from being published, partly on the idea that we should not allow people to steal top secret information and put it in the public sphere, that could be dangerous to national interests, but also because the document was highly critical of how the Johnson and Nixon administrations had handled the war, and basically blamed them for bungling the war and turning it into a far worse fiasco than it should have ever been. The government sued the New York Times, and in the lower federal courts got an injunction to prevent the paper from publishing. The New York Times brought the case to the Supreme Court, and the Supreme Court ruled 6-3 that it would not stop the government from publishing the records, so that even though they had been stolen and they were classified and deemed top secret, the court basically said once the secret is out, once it gets into the hands of the public or the press, then it can be freely disseminated at that point, and they were not going to impose prior restraint. Basically, they left it open if the government could somehow prove that the New York Times had stolen the documents or had violated the rules for classified information, which basically only can apply to employees that are handling the information. It really doesn't apply to the public at large, that possibly they could bring a criminal case, but that the court was not going to enter a civil injunction against the New York Times to stop the publishing of the Pentagon Papers, and they were indeed published. Having said that, in about the same time period, in a case called Hazelwood versus Kohlmeyer, the court allowed a principal and school district officials to censor a high school newspaper, to take out articles about the war, about protests, about other types of things that the students had put in. And in this situation, however, the courts made a distinction that's going to become a little bit important when we start talking about pornography and some of the other aspects of speech where the court has gotten themselves into hot water over the years. But the distinction they made here was that a high school, in those days at least, was mostly dealing with people who were underage. The age of majority was at that point, I believe, still 21. And so most 99.999% of high school students would still be considered children at that point. They were not adult citizens. And the court basically said that the school and the school district stood in the place of the parents of the students. And there's an actual doctrine called parens patria, which basically just means in the place of the parents or in the place of the father. And because the school was dealing with minors and was standing in the place of the parents, the school basically had the same controls that parents would have. And if they wanted to prevent the students from publishing certain things, they had the right to do that. Now, even at that point in time, and certainly today, that probably would not apply to a college newspaper, because college students, by and large, and particularly today, most folks, when they get to college, they're 18, they are adults. And a school, and now here again, it gets very tricky, because when we say a school, the First Amendment only applies to governmental action. Now, in many situations, certainly in elementary school, junior high school, in large parts of the country, the school districts are run by the local, county, or state government. They are arms of the state. So when you have school officials trying to impose censorship, that is the government officials coming up against the First Amendment. And the same thing would apply at many universities. The University of Rhode Island, University of Massachusetts, University of Connecticut are state-owned and run institutions. They are also arms of the government. So they would fall under the rules of First Amendment protections, where the government would be unable to censor or stop most types of speech. The rules get to be a little bit different if you're going to a private school or you are enrolled in a private university, because, again, they are not the government. They have a little bit more control over what you do or say, particularly if you're doing or saying it on their campus or in their names, than these state schools do. One of the tests that the court uses to determine if speech can be stopped and censored is, does it constitute a clear and present danger? So certainly, yelling fire in a crowded theater when there is no fire constitutes a clear and present danger. You can not only be criminally punished for that, but they could try and stop you from saying it. And I suppose, again, in times of war, in times of insurrection, certain top secret items, certain classified items, if they got out, it could constitute a clear and present danger to the country, to the public, to the government, and therefore the court would say that that could be stopped by prior restraint and probably even punished criminally if you were to disseminate it. The First Amendment has had a long and rocky history in the 1900s and the 20th century, and partly because of what was going on in the world during that time. Particularly 2 points in time, there were movements in other countries that also kind of were active in this country that caused great alarm. One was in 1917, after the Bolshevik Revolution in Russia and the communists took over there, and made the explicit claim that they were out to overthrow every government on the face of the planet and bring all countries under communist control. During that time, the courts were much stricter in terms of prohibiting speech, prohibiting demonstrations, prohibiting activities. And then again, in the early 1950s, after World War II, after the Russians had pretty much taken over all of Eastern Europe and imposed communist governments on the former states that were there, and the Chinese had moved into, communists had taken over China, North Korea, Vietnam, it was felt that there was a clear and present danger in some cases, and the court actually kind of reduced the clear and present danger to a clear and probable danger, at least in the 1950s during the communist scare. Again, the courts were much more open to prohibiting speech, to punishing people for publishing certain things, for belonging to communist organizations, under the idea that The communists were explicitly saying they were trying to overthrow the established government by violence, that they were basically in favor of insurrection and rebellion, and that the government had a right to limit or control that type of speech, or to control literature about that, or control people belonging to those groups. By 1957, though, the court had begun to back away from that and basically said that only active membership in a Communist Party that wanted insurrection or rebellion would be punishable under the federal law. And today, that's even moved further back. There are communist parties operating in the United States today. Again, if they expressly came out and began to agitate for overthrow of the government, possibly that could be banned, but no such activity has really gone on since the late 1950s. Fighting words, profanity, hate speech. Fighting words are an interesting thing. They're a difficult category. There's basically only one case from the 1940s called Chaplinsky versus New Hampshire, where somebody basically went up and made nasty comments to someone to provoke them into a fight. The person making the comments was arrested, basically on kind of a disturbing the peace through their words type charge, and the court upheld it, saying that words intended to provoke a reasonable person into violence were not within First Amendment protection and could be prohibited by the states. In 1971, the court kind of backed off from that in a case called Cohen versus California. The defendant in the case wore a T-shirt with highly controversial and offensive writing on it. And again, he was arrested and charged kind of under disorderly conduct by virtue of what was written on his T-shirt charge. And the court there said that that was not sufficiently incendiary to be considered fighting words. So writing it on your chest was not incendiary, where saying them 20 years earlier, 30 years earlier, had been incendiary. Again, since 1971, it's been pretty much held that it's not a lot of power behind the fighting words exception to the First Amendment at this point in time. Profanity, swearing, using bad words, normally cannot be limited by the government. Now, again, if you are a minor in school, it can be limited. If you are attending or part of a private organization, they can have rules prohibiting it. But beyond that, in terms of putting it on the internet, in terms of handing out a pamphlet with it, in terms of standing on a street corner and yelling it out, it is protected by the First Amendment to a great deal. There have been a lot of things spoken about in recent years in terms of something called hate speech. Hate speech is basically the idea that we're using our speech to defame a particular group of people, a particular set of persons within the society, and possibly would usually be tied in with the idea that we're trying to intimidate and harass and make them fearful so that we can basically indirectly control their actions by way of this hate speech. There was, going back in the 90s, a movement to try and pass laws that would make speech of this type illegal. But in a case called RAV versus St. Paul, there was an ordinance in the city of St. Paul, Minnesota, that said basically you could not make any statement that was aimed to produce fear or alarm in a group of people or in a particular person. And the court overturned that, saying it was way too broad, it was way too difficult to define what that meant, and that it was just too much of a restraint on speech to allow that to be stand as a statute. However, in later cases, the court did uphold different state laws that allowed for an increase in penalties, an increase in jail sentences or fines if you committed a crime and used hate speech as part of the commission of the crime. So if you did malicious damage to a building by graffitiing it and you used hate speech in the graffiti, then the state could turn that from maybe a misdemeanor into a felony because of the hate speech aspect of it. And the court also has upheld a Virginia law which prohibited cross burnings if they were found to be used with an intent to intimidate a specific person or a specific group of people within society. And certainly there was a long history in the South of cross burnings to try and intimidate the black population into not being politically active, not being socially or economically active. And again, the court let that stand, even though that, burning a cross is certainly making a statement. But they held it was okay to control that burning of a cross, even though it had a speech aspect to it. Symbolic speech, expressive conduct. So there are situations where you don't use any words, but by your activity or your actions, you are making a statement. And symbolic speech, the definition is nonverbal communication. Now, saluting the flag. As we were coming out of World War II, during World War II and coming out of World War II, all students across the country were required every morning to say the Pledge of Allegiance, to salute the flag. Many places you had to sing the Star Spangled Banner, America the Beautiful. This was required. And during the years of the war and immediately after, the courts tended to enforce that. But later, beginning in the 1950s and 60s, several different religious organizations brought lawsuits saying that they did not believe in making such oaths or pledges or in saluting flags or that type of thing, and that it was against their religious beliefs, and that the court could not force them to speak and to say something they didn't want to say or they didn't believe they could say, getting us back to Masterpiece Cake Shop and our baker. And beginning in the late 1950s and going to the 1960s, the court became very sympathetic towards this, so that today you cannot require a student to stand up, make the Pledge of Allegiance, and to salute the flag or to sing the Star Spangled Banner. The courts have basically said this was an effort to force children to accept certain beliefs and then to verbalize them. In the Fourth Amendment, again, particularly in governmentally run and controlled schools, the First Amendment does not allow this. Again, going back to the Vietnam era. And it's interesting because kind of what happened, having grown up during that time, the country kind of went from a period where during World War II and immediately thereafter, tremendous patriotism, tremendous outpourings of love of country, of duty to country, of putting America first before your personal preferences. And with the advent of the Vietnam War, and that came all crashing down very quickly. It was a very short period of time, actually. World War II only ended in 1945. The Vietnam War really cranked up in 1960, so that it was about a 20-year spread, one generation. So it was the children of the men who had fought in World War II were vehemently protesting against the Vietnam War, and the attitudes and the conceptions of the younger generation of the country were very different from their parents. The courts at first tried to maintain the old status quo, the old order, tried to silence some of these things, but very quickly gave in and said, no, First Amendment allows protests, allows disagreement with the government, allows you to state your views. In a case called Tinker versus Des Moines, students in a public high school organized a demonstration where as many of them as they could get to agree to it wore black armbands, which in many cultures and even in American culture in the past had been a symbol of somebody had died and that you were in mourning. To protest the Vietnam War, they would wear black armbands to school every day. The principal and school department attempted to punish them and to stop them, and the court said, no, you couldn't do it. That the armbands was symbolic speech, and as a government entity, the school had no power to stop that. Okay, took a little stop there. On the other hand, and to show you how conflicted the country and the court was at this point in time over exactly what was allowable speech and what was not, at that point in time, there was still a draft. There was something called the Selective Service System, At age 18, every young man had to sign up for the selective service, and you were handed a card. It did not have your picture on it at the time, but it was like a driver's license. And you were supposed to carry it with you at all time. It had your name and it had your eligibility status for the draft, and it had a number on it so they could identify you. And many young men who were protesting the war took to burning their draft cards. They were only made out of some kind of cardboard, and with a cigarette lighter, you could easily make them go up in a puff of flame and smoke. That became very popular. And even though in Tinker, they said the students had the right to wear armbands in protest, in several cases, they held that you could not burn your draft card and that you'd be subject to criminal and civil penalties for burning your draft card. Flag burning became something that started happening at this point in time, where people would burn an American flag in protest. And again, the court, after in early years, going back in the early part of the 20th century, not allowing it, basically came to say that flag burning is a form of symbolic and political speech, and political speech gets the highest protection under the First Amendment. Religious speech comes very close, but the courts are they're more diligent in protecting political speech than just about any other type of speech. And they held that flag burning was not just symbolic, but it was a form of political speech, and therefore state and local laws about not desecrating the flag could not stop people from having demonstrations where the flag was in fact burned. Nudity. There has been a long history of the states and municipalities, towns trying to prevent nudity, particularly in terms of nude shows and expositions. And generally, the court has upheld the right of states to have some control there. So public expressions of nudity can be regulated. Now, it can't be entirely prohibited at this point, but it is allowed to be regulated and controlled. And again, we haven't talked about it too much this year, but one of the basic concepts that the court has used over the years in dealing with the states is the idea that the states have certain police powers that allow them to handle areas that concern health, education, safety, and welfare of the people, and that they held that setting certain minimum moral standards was part of that police power, was part of that health and safety. Now, that has greatly lessened over time, and today there's far less control of it than there was 30 years ago, and certainly than there was 100 years ago. But there still are circumstances, and particularly, again, if you're dealing with children, the court seems to cut a fairly hard line between dealing with children and dealing with adults in the First Amendment. So situations where children are becoming in contact with public nudity could probably still be controlled, certainly more so than it could be in adult situations. One thing that was a very hotly contested issue. It's kind of not fought over anymore because the court had been so vehement in its position on this that not too many cases have come forward in the last 15 or 20 years. But under the idea of freedom of the press, the reporters in the mid-20th century began to promote the idea that they had the right to have confidential sources, that they could get information from people, and that they could not be forced to reveal from whom they received that information. There was never any recognized privilege as such under common law for this situation. The Constitution does not really spell it out. It's silent about this. The First Amendment is silent about it. But the idea that, well, in order to fully report the news and to fully find out what's going on, we need confidential sources. So therefore, it has to come under the umbrella of freedom of the press. A number of newspaper outlets and reporters brought cases, really pushed this. But it came smack up with another part of the Bill of Rights. Under the Sixth Amendment, a criminal defendant has the absolute right to confront anyone who is a witness against them, to compel testimony of people who might be helpful in their defense, And many of the situations where reporters had confidential information, particularly in the 70s and 80s, concerned areas that dealt with drugs and organized crime, prostitution rings, and that. So many times their confidential sources had incredible amounts of information about criminal activity. And the courts were adamant in saying that this was not a protected situation. And particularly if there was a criminal defendant who wanted to call a reporter to the stand and have him reveal his confidential or her confidential source, because that might be helpful to their defense, the courts are adamant that there was no such thing as a reporter generalist privilege to protect their sources. And a number of reporters were sentenced to contempt of court and were put in jail for refusing to reveal who their sources were. As I said, the courts held fast to that view. They did not relent on it. And so there are very few cases in that area today because it's kind of known what the rule is. And that if you don't follow a court order to reveal your source, you will end up in jail under contempt. We talked a little bit about defamation last week. And again, we said defamation is the injuring of a person's reputation by making false public statements. Slander is verbal defamation. Libel is written defamation. Defamation is a civil tort. So without any statutes under the common law, if you gave words that falsely ruin someone's reputation, you could be held to account for that. And what would happen to you is that you could be sued for damages, for lost income, mental anguish, loss of relationships. You could end up being sued for millions upon millions of dollars for ruining somebody's livelihood or their life or their relations with other people, with their family members, their spouses. In many states, allow something called punitive damages, so that if you could show that this was done with some type of intent or some type of malice, the awards could be multiples of what the actual provable damages were. And in many states, there were no upper limits. And again, they didn't have to, the punitive damages didn't have to be tied in with actual losses. This became a very difficult thing for newspapers and magazine publishers, and even for broadcast publishers, radio and TV, because even if the person couldn't prove that they had been defamed, the lawsuits involved in this could cost millions upon millions of dollars and actually had a chilling effect on what people were willing to publish. Well, in the early 1980s, the court came down with a case called New York Times versus Sullivan. And in this case, Sullivan was suing the New York Times, saying they had defamed him with untrue statements. And previously, that had been the only requirement, to prove that the statements were not true. The Supreme Court, in looking at this, said that based on the First Amendment freedom of the press, they created a new rule for public figures. And they said that in order for a public figure to sue for defamation, they would have to prove actual malice. Malice is evil intent. Actual means the evil intent was the operative thing in what you were doing. So basically, in order now for a public figure to sue for slander, for defamation, they would have to prove that the media outlet had deliberately known that something was a lie, it was untrue, and went ahead and published it with the intent of hurting or injuring them. Very difficult things to prove when you come right down to it. Not easy things to establish in front of a jury in a court of law. Public figures is a very broad category. It includes all politicians, public servants, movie, TV personalities, sports figures, probably authors, musicians, religious leaders. A private citizen can become a public figure for a limited time or circumstances. If they're in an accident, perform a rescue, win an award, and the ceremony is televised or in the newspapers on Facebook. But by and large, you have to somehow have deliberately gotten your name out into the public sphere to be held to be a public figure. And there was even a case where a woman who was an heiress to Firestone Tire, which is a big, big company, she would have been a multimillionaire, was involved in a nasty divorce, and the court ruled that even though her father was a famous business person, well known, that she was not a public figure. So just being rich and getting divorced did not make you a public figure. Um, it still is a difficult thing. The internet has made it even more difficult to determine who is public and not public. Certainly, you can put a cute little video of your child on Facebook or YouTube, and suddenly 20 million people around the planet have looked at it. Is your child now a public figure? I'm not quite sure the courts have gone that far in actually defining this, but it is a interesting question as we become more, all of us become more and more visible on the net. At what point do we turn ourselves into public figures where we no longer have the protection of slander and libel laws? There's also the idea of invasion of privacy. Most states have, at this point, said that that is a tort, that you cannot make unapproved inquiries into the private life of someone, and that certain areas are just not subject to being open to being put into the public. Now, this is very difficult because if the information is out among other other third parties, and the press can usually get it and use it, but there is a certain line over which they cannot do, and certain things that if you have maintained them as private, they have no right to go digging through your trash cans or hacking into your computers to find out what's going on, or bugging your house to find out information that you want to keep private. One of the biggest areas of contention in First Amendment cases has to do with obscenity. Obscenity basically means something that is patently offensive in terms of civil sensibilities and morality. It can be found in books, in pictures, in movies, on the internet. It's just an idea that something is morally not correct and proper and should not be put before the public. Now, the society's idea of what should be censored and what is obscene and what is not has changed dramatically over the last 100 years, and the courts have been running trying to keep up, and I think at this point have pretty much given up trying to keep up. When I was a young person, there was a famous phrase called "banned in Boston," because Boston had very strict censors. They banned all kinds of books and shows and publications, and of course that always had the negative effect of once you banned it, then everybody else in the country ran out and bought it, and even the Bostonians would drive over the line to New Hampshire, Rhode Island to buy it, because, my God, if they banned it, there must be something good and juicy in there that'd be interesting to read. But there were these attempts to try and do that. In 1957, the court tried to define obscenity as being utterly without redeeming, something that is utterly without redeeming social value or importance. And if viewed by the average person using community standards, would find that showing or displaying or conveying this material is improper, and that it also, as taken as a whole, appeals to a prurient interest. Prurient gets into the idea of sexuality, or maybe even deviant sexuality. So basically what the court was trying to say is that, well, yeah, there are certain things. If it involves sexuality, and probably if it involves sort of deviant sexuality, that by public standards should not be shown, talked about, revealed, and it has no socially redeeming value. It's not a work of art. It's not a expose of some crime or some aspect of government. It's not a documentary. Then it can be banned. It can be deemed to be obscene. The test created more problems than it solved. Prurient interest was never totally defined. Redeeming social importance was never really defined. Community standards quickly became a problem because what was deemed fine and okay in New York and Los Angeles was seen as hideous and horrible in Des Moines and Topeka and Little Rock and other places. So it became an impossible standard to maintain. In one of the cases, Justice Stewart quipped that even though he couldn't tell you what obscenity was, he knew it when he saw it. That's not a legal standard that other lawyers and judges can use to make a determination as to what do we do with this case? What do we do with this person? And of course, the penalties were very severe here because not only could obscene material be prevented from being sold and published and disseminated, but there were criminal laws attached to it. So you could incur fairly severe criminal penalties for possessing or distributing these materials. In 1973, the court imposed what is still pretty much the standard today, although it has been greatly loosened in its application. But they basically said that in trying to determine something is obscene, you have to look at three different things. Does the average person applying community standards find the work as a whole appeals to the Puritan interests? Does the work show patently offensive sexual conduct? And that needs to be specifically defined in the statutes prohibiting it so we know what that conduct is. And does the work as a whole lack any serious literary, artistic, political, or scientific value? Again, it's better than the 1957 Roth test, but it doesn't really give us a full answer as to what are they talking about exactly. When would somebody have crossed the line here? Courts have pretty much, at this point in time, the lower courts at least, have substituted a reasonable person in the situation rule for a community standard rule, again, because even today, although with the internet that is changing, but even today, people have different standards in New York than they would have in Salt Lake City or Billings, Montana. So the community standard, and in a time when, because of the internet, works of art are immediately available in any community, any place, the community standard becomes a very difficult thing to control, to determine what it is and to apply. The internet basically became the tsunami that broke the wall of laws trying to prevent obscenity, because now, for the first time, people in their own homes could procure any type of information that they wanted, where previously to the internet, the stuff had to be conveyed. You had to go to a store that sold it, or meet up with somebody that would give it to you, or find a magazine where it's published, a book where certain things were being described. It basically involved commerce in order to obtain obscene materials prior to the internet. Now, with the advent of the internet, we reach a situation where in order to stop the activity, the government would basically have to set up sex patrols going into people's homes and bedrooms and going onto the computers and their laptops trying to find out, well, what is it that you've been looking to? And no politicians and most judges were not at all interested in going that far or in doing that. As we talked about last week, Congress tried to pass some legislation making it a crime to have obscene material that could come into the possession of children. But again, because computers came to be prevalent in almost every home in the country, and children are better at using them than their parents and understand the blocking controls better than their parents, this quickly fell too, because there was no way to enforce it. And the court actually struck down a good chunk of the statutes that attempted to do this, attempted to control it by way of saying, well, you can publish it, but you better make sure only children look at it and not adults. Now, the huge exception to all of this has to do with child pornography. In a case called New York versus Ferber, the court determined that the state has an overriding, compelling interest to protect children, and that since children are children, children can never consent to engaging in sexual activity, so therefore to film them engaged in such can be held to be criminal and can be severely punished. And that here, the First Amendment gives way to the necessity and the duty of the state to protect and foster the health and welfare of children. The court has never backed off from this. Police and prosecutors have not backed off from it. So the production and possession of child pornography is still a felony in almost every part of the United States. They are felonies under federal law, and people are still prosecuted regularly for this. Now, interestingly enough, with certain types of animation that has become so good it looks almost real. There were cases brought saying that virtual, non-photographic depictions, anime and that type of thing, digitally computer created images should fall into the same category as child pornography if they depicted sex acts with children. And the court backed off and said no. Well, the reason we have this rule about child pornography is because we're protecting the children. If this was an image created totally out of the artist's mind or by a computer, no child was involved, no child's rights have been violated. Nope, it doesn't, you cannot control that. So an interesting digression there. One of the things that the court applies, one of the standards that it always applies in First Amendment cases when they're looking at a state statute or a local statute or ordinance, is something called overbreadth. And overbreadth literally means too wide or too large or too big. You're trying to encompass way too much here. Statutes that run up against a known civil right must be strictly construed, strictly written to create as little interference with that right as possible. So there are many times when the court has struck down statutes concerning First Amendment issues, not by saying the statute is totally wrong, you just can't do that, but by saying that, well, you may have the gem of an idea here. You might be able to prevent some of this from being said. However, the way you described it, the way you stated it in your law is so broad, you're pulling in a whole bunch of legal speech that is protected by the First Amendment, and therefore the statute must fall. An example of that, statute that says, or an ordinance says that no one may engage in disorderly conduct. What does disorderly conduct mean? The court has thrown out those used to be almost universally existing throughout the country, particularly as local city and town ordinances, county ordinances, to try and rein people in and to, get the drunk person off the street corner on a Saturday night. You charge them with disorderly conduct. The court spent a good deal of the 60s and 70s and 80s throwing those statutes out, saying that they have to specifically describe what is the conduct. You can't just say disorderly conduct and leave it up to the officer or the judge or the jury 6 months later to decide what was disorderly or not. You must describe what actions constitute the crime. And certain actions certainly can. Public urination is one that seems to have stood the test of time. It can be prohibited, and it can come under what you would have otherwise been a disorderly conduct statute, but it must specifically state that. Loitering means to be hanging around, to be standing in a place without any reason for being there, without being engaged in any particular activity. Again, the court threw out most of the loitering statutes on the idea of saying, what is loitering? When does it become loitering? So if you're standing in front of Mrs. Smith's house waiting for a bus, it's legal, but if you're just standing there because you feel like standing there today, it's now a crime. So loitering statutes were very much held to be overbroad. I think I'm going to call it. We've done 53 minutes here. We're still in the first section here, and I have a few more pages to go in that. But we'll stop here, and we'll pick up in the next video.